and good morning, everyone. Thank you for joining us for today's webinar. I just jumped on quickly to introduce our moderator today, Bert Barron. Many of you may know Bert from his moderating of these webinars for Drugs Network in New Jersey, as well as from his longtime voice on the radio. But Bert is a good friend to the partnership, but also to this issue. He's really shown a dedication to raising awareness and educating the residents of New Jersey about issues surrounding substance use. So, Bert, thanks so much for joining us. Bert is a native and lifelong resident of New Jersey, and he is a New Jersey Broadcasters Association Radio Hall of Fame inductee and award winner. He's an award-winning writer, producer, and podcaster, and over a career that has spanned over 25 years in New Jersey, New York, and Pennsylvania radio, which is why we may all be familiar with his voice. Bert has garnered a nomination for an industry celebrating Marconi Award from the National Association of Broadcasters as Best Large Market Personality, as well as winning more than a dozen Jersey awards from the New Jersey Advertising Club, including the prestigious Best in Radio Award. Bert is the board vice chair of the New Jersey Broadcasters Association and is the co-host and producer of Be Inspired podcast and the vidcast series. He also serves as a consultant advisor and producer editor on many special projects, including Mobility Matters with Keep Middlesex Moving and TSG Time with the TSG Performance. And so we're so happy and pleased that you could join us today, Bert. And no further ado, I will turn the webinar over to you.
Well, Angela, thank you very much for that introduction and good morning. And it's an honor to be here again today. This happens to be the 26th annual webinar for the members of Drugs Don't Work in New Jersey, the partnership's free drug-free workplace program. So we welcome the current members of the program, and we extend a special welcome to employers in New Jersey who have joined us for the first time. Welcome. And we know a few of you joining us today are from outside of New Jersey, so welcome to you as well. Just a few housekeeping details before we get started. The slide presentation and a recording of the webinar will be sent to all participants. Some of you submitted questions in your registration, and those of you who have a question can enter it in the chat. We'll try to answer as many questions as we can after the slide presentation. The overall goal today is to get you up to date on what it means to be a drug-free workplace in 2026. And there is a lot of ground to cover on that important issue. Providing an update on legal and legislative developments, both on the national and state level, are two attorneys with expertise in the field. Nancy N. Delogu, well known to the members of our drug-free workplace program. She has shared her expertise for more than 20 years. Nancy is an attorney and a shareholder of Littler Mendelson PC and is a nationally recognized authority on federal and state drug-free workplace and drug testing issues. She has spent much of her career focusing on workplace drug policies and procedures, including programs that are mandated by the Department of Transportation. Working with Nancy today is Lauren Marcus. Lauren is also an attorney and a shareholder at Littler Mendelson and works out of their Newark, New Jersey office. She represents and advises employers in various aspects of employment law and regularly advises and counsels clients on a wide array of day-to-day concerns. And this includes leave of absence issues, wage and hour questions, employee manuals, and policy development. Nancy and Lauren, welcome. It is all yours, and we'll turn it over to you to take it from here.
Thank you so much, Bert. That's such a charming introduction. I cannot believe that I've been presenting to this group for so long, but it has been an honor and a pleasure. And it's nice to be back and to be invited back to do it again. And I appreciate particularly that you went out of your way to say that I'm an expert on drug-free workplace policies and responses, as opposed to many of my colleagues, never Lauren, who would say Nancy knows everything there is to know about illegal drugs to clients sometimes, which can be awkward. So we're happy to be here. Hopefully I can bring some of the the updates here and the national perspective. And Lauren is always, she's in Newark, right? So she's seeing it on the ground. So thanks for having us. Let me see if I can get my slides to advance here. and we'll begin the presentation. Obviously, this is just our background here. You've seen us here before. This is just if anybody later needs to reach out to me and Lauren, it's available. I have an informal agenda to cover today, but I'm not going to be okay, 5 minutes on can you have a drug-free workplace? And but these are some of the topics that we are going to cover today. And one thing that I wanted to do a little bit differently from how we've done it before is rather than kind of work up, start with what's new and work up to what's okay to do, what we can always do in New Jersey, kind of start out the other way around. Like, here's the level set. Here's what the law allows you to do. Here's what a drug-free workplace might look like. And then, here are some things that are changing and some questions that you might be asking or getting from your, constituents, whether those are workers or patients or, medical professionals, whoever you work with. So can you have a drug-free workplace? As Bert said, what does that mean? Wait, is marijuana legal? We're hearing a lot of things out of DC about that right now. And if you're confused, I can guarantee you that people who are expecting and expected to follow your policy are even more confused. Making drug testing work for your workplace. Can we require employees to go to treatment? A little side note, because I know drug-free workplace is not all about just detection and testing. And then we're going to talk a little bit, well, really, Lauren's probably going to talk about the psilocybin trials in New Jersey. I look forward to watching that from afar. So without further ado, this is a slide that you will have seen before with a little bit of tweaking, talking about what is cannabis and what is marijuana, because we're going to talk about marijuana today. And New Jersey uses the term cannabis in its cannabis reform law. And I wanted to just kind of level set so we're all on the same page. THC, cannabinol, those are the active psychoactive ingredients in marijuana that we talk about. There are reportedly hundreds of different chemicals found in the marijuana plant. But THC is the one that we've been testing for the last 30, 40 years. It's the one that, reportedly gets people high. It's the one that is regulated as a Schedule I controlled substance by the federal government. And there were reforms to federal law a few years ago, 2018, I think, that said that a cannabis product, or a hemp product was the term they used, are lawful nationwide if they contain less than 1/3 of 1% of THC. And that's how we began to see products like CBD products on the shelves, right? This is another chemical extracted from the cannabis plant, the marijuana plant, but made available because it's not supposed to have psychoactive impacts. And that's how, people said, well, CBD products, but we can get into what is actually in some of those products because they're not regulated by the FDA. But employer drug tests always look for the presence of THC, not CBD. We can talk about that. But if somebody says, oh, I shouldn't have tested positive, I was using a legal CBD product, that shouldn't happen, right? Because they're not supposed to be anything more than a trace amount of THC in your CBD. And so that's why we distinguish. We're talking about marijuana and marijuana products. We might be talking about THC, Delta 9 THC. We could be talking about Delta 8 THC, which is another THC strain found in marijuana. We could be talking about synthetic cannabinoids. And so whenever we're talking about THC, Lauren and I will use the term marijuana just to kind of as an umbrella term, if you will. And if we need to, we're happy to talk about the specifics. By way of quick update, it was the case that when Congress modified or adopted these laws allowing hemp products with low levels of THC, it sort of inadvertently, perhaps, maybe it wasn't so inadvertent for some of the members of Congress. I work in Washington, D.C., and I'm going to be the last person to try to predict what Congress was thinking. But they talked about THC, Delta 9 THC, and how more than 1/3 of a percent would be too much. And they said everything else is fine. That allowed an entire industry to spring up, making vapes and products using Delta 8 THC, which is also impairing and psychoactive. just less well known, certainly different outcomes, and a lot of other related products. If I had to use an analogy, it's kind of like, farmers grow corn, and from corn we get cornmeal and we get animal feed. We also get corn syrup, and so like all of these different products coming out of the marijuana plant. Uh, at some point after the hemp laws were amended, it was okay to have any marijuana product on the market as long as it didn't have more than a third of a percent of THC. With the last budget bill, Congress actually stepped in and said that they will regulate, and it is not okay to have other cannabis products like Delta 8 THC, and that they will be regulated. And this caused a lot of consternation in the industry. It's currently, being sorted out, if you will, in terms of negotiation, and it has to do more with marijuana scheduling. But I just wanted to toss that out there. That when we talk about marijuana, we're mostly talking about Delta 9 THC. That is what your workplace tests test for. And we were talking about the umbrella. And I probably am not going to get any further into the weeds, joke intentional, bad pun intentional, on that. But happy just to let you know that we know there's more out there to what is marijuana, and that this is becoming more of a workplace issue. But we'll try to put it out there. For the person who asked in the chat, are elected officials subject to random drug testing? They are not. And in fact, there was a point, not too distant past, but it might have been late 80s, early 90s, where the state of Georgia said, if you want to run for office, you need to take a drug test and you have to publish your drug test results. And someone challenged that as being unfair and violative of the Fourth Amendment against searches and seizures. And this went to the US Supreme Court, and the US Supreme Court threw that mandatory drug testing requirement out because the way the statute was drafted, any candidate for statewide office in Georgia could schedule his or her own test. And they said, this is essentially performative. It is not going to catch anyone who is currently abusing drugs. And therefore, the purpose of the search is not constitutionally, supported. So no federal tests, no tests for elected officials, at least as a general rule, certainly not in Congress. Fun fact, every congressional office is its own employer. So Congress is like an entity, but every office has a different process. And so there probably are some congressional offices that have testing policies for their staff, but I'm not prepared to break that down today. All right, can we have a drug-free workplace? Of course you can, as long as you know what that means. Lauren and I sometimes like to go over this because we still get questions. And Lauren, I'll probably just sort of like say, how are you still getting questions like this? But just to introduce the topic, it is okay to have policies prohibiting the possession and use of marijuana, cannabis, including vape and edibles, and all other illegal drugs at work and during the workday in New Jersey, right?
Yes. It's really interesting. Over the past few years, I feel like the tide has changed, and a lot of employers, it's kind of gone the other way. So, a few years ago, I was getting questions like, this person smells like marijuana. Can't I fire them? Can't I do something? And, there's restrictions on what we can do. You need to be able to show someone's actually impaired at work. And now a lot of the questions I get are like, oh, this happened. And like, I'm convinced this guy was definitely, under the influence or stolen, but I can't do anything, right? And I'm like, no, we have not gone this far over. Oh, like it's like a few years ago, people thought they could still do anything. And now it's like almost overcorrecting where employers think they're not allowed to do anything. So I do think it's important to note, you can have policies, you should have policies saying that, marijuana and marijuana products like cannot be at the workplace, that people cannot use them at work, that you cannot be impaired at work, discipline people who are. The law protects lawful off-duty use. So you cannot take action against someone based solely on lawful off-duty use, which means if someone tests positive for, THC or marijuana, you can't fire them because they could have, used it 3 days ago, not at work. But if you have reason to believe and, a reasonable suspicion, or, if you see someone using marijuana at work, you can still take action against them. You should take action against them. It's still your workplace. It's kind of like alcohol. Like alcohol's legal. We don't let people to show up with a can of beer in their hand. So we don't have to like overcorrect it too much.
Yeah, I actually see that I see that this it comes up where people say, well, they're smoking in the parking lot before they come in. And I'm like, well, is it your parking lot or is it the supermarket parking lot? Because if it's your parking lot, then it's okay to have a rule that says you can't be using that or bringing it on premises. And for those employers that have, sort of federal connections, when we get into a little bit of the discussion of what's going on with the federal law, pay attention here. There will be, uh, you know, um, there are things that you can do and things that you can't do, but these are sort of like core things. Your policies can say that. And what I do find, and maybe this is the biggest thing in terms of rather than overcorrecting, is this is an opportunity for the people on this call, because I know you're all active in this space. This is an educational opportunity, right? You can teach your employees what you expect there. You can put out reminders. You can teach your supervisors. There may still be, of course, people who struggle with substance abuse or who choose to engage in marijuana or cannabis use off premises. But if they come to work, it's an issue. Um, I mentioned that Congress was getting into regulating, or said that they will, be regulating the use of cannabis products that are not just THC, and was reminded by a fellow panelist here that New Jersey is working to regulate the sale of CBD as well. And it's later this year, only businesses with a license are going to be able to sell certain CBD and THC products in New Jersey. And I don't quite know whether those are THC products. There's a certain amount of THC above the federal level, but the reason you can buy like CBD creams and things in, I guess CVS or Walgreens or across the country, is that the federal law does not regulate that. So watch that space. I will say I like a policy that says don't bring CBD products to work. And people will say, but it's totally lawful, like legal. It's like, sure, but do you allow people to walk around with a, beer and your premises, or do you ask them to like not bring it inside? Sometimes it's a lot easier to not have to have the discussion with your employees about, well, what's in that product? Does it have? And they're like, no, it's fine. But do I want to be spending time policing that, or can I just say leave it in the car, don't bring it on premises? And that can be helpful. All right, so back to can we have a drug-free workplace? And I wanted to make this as interactive as possible. So all of you guys on the webinar chat, I would like you to think about like not just shooting questions in, but putting in answers. Or in a minute, I'm going to ask you like, what more would you like to know? I'm going to give you like, we're going to play lawyer law school, where we get fact scenarios and you have to like ask questions and render legal advice on the fly. So you get to do that today. Can I prevent workers from using their prescription medication at work? Anybody want to guess? Lauren, do you want to give me an answer?
Well,
She's not going to give me a lawyer answer. Well, okay, so here's the bottom line. No, you cannot prevent people from using their prescription medication at work. And this is good. Somebody, as Mary Pat got it in, other people, yay, great. You're all coming back with no. The reason you can't require, you can't keep people from using their prescription medication at work is that this is their prescription medication. And not only do we have federal law protecting individuals with disabilities, which some people with prescription medications may be or definitely are. We have state law, right? Law against discrimination. Also,
I was thinking prescription marijuana, but
oh,
I was in that point, and I was like, yeah, but
is that a thing? Prescription marijuana? Not yet, right? Right now, you cannot prescribe cannabis as a matter of federal law. It's illegal.
Exactly.
About that in a minute, but yeah, no. So there is a recommendation you can get in New Jersey and in other states to use marijuana, but you take a look at that. You can't fill that at CVS. That's not a script, right? So it does not have federal protection, and it may have state law protection, but the New Jersey law doesn't say, remember, we just went over this. It does say you can tell people they can't bring it to work and use it at work. So that is, there is no prescription medication and stuff like that. Marinol is the exception, Mary Pat, you're correct, but you can prevent people from using the Marinol at work, possibly only if it's dangerous. So like, we move forward here. Can I tell workers they cannot have marijuana at work? This is the gimme. Yes, you can tell workers they cannot have marijuana at work, even if it is quote unquote prescribed, or as I prefer the term, recommended by your state, and they're using within your state medical marijuana laws. Somebody's asked a really good question, which is, do employers have to honor out-of-state cannabis card from prescribers that are not their personal provider? And briefly, I always like to look at the state law because this does vary by state. But as a general rule, state law protects people who are using in accordance with the state program, right? So I know you've got Pennsylvania right nearby. That one's very clear. If you live in New Jersey and go and work for Pennsylvania and you have a New Jersey card, Pennsylvania is not going to honor it. I think New Jersey is less definitive, but that is my understanding. Have you seen anything different, Lauren?
No, we're not definitive about anything.
Okay. Yeah, but generally speaking, no, like out-of-state cards are not usually being used within, the meaning of state law. So then it gets a little dicey because in New Jersey, if you're using medically, whether you have it from the state or not, I would still want to look at the law against discrimination because those individuals may be considered impaired, not impaired, but protected in other ways. Yeah.
Right. And that's the biggest thing that has been overlooked. Not the biggest. It's one of the big things that's kind of slipped through the cracks in New Jersey with the new law is, now fewer people, in my experience, at least from what I've seen, are coming forward with medical marijuana cards and using that as an explanation at work. Now it's really this is legal, I'm protected, you can't do anything about my lawful off-duty use. And there have been fewer discussions or instances coming up regarding medical marijuana. But it still is a big play because when New Jersey, passed its law on recreational marijuana, they didn't get rid of the medical marijuana law. They didn't get rid of the Jacob Honig Act. They didn't amend any of that. So technically now, if someone tests positive for marijuana, even if there's no adverse action, I guess, but like technically you're still supposed to send that letter saying, oh, you tested positive. Do you have a medical marijuana card? Or, and the case law in New Jersey regarding whether you have to accommodate people using medical marijuana at work is very vague. It's very employee friendly. And so you do still have to be careful. We say, yes, you can tell people they can't use marijuana at work, but there is still that little carve out for if it's medical, you have to at least engage in the interactive process and kind of work with them a little on it.
Yeah, but not using it at work as opposed
yes,
to.
No, definitely not using it at work and not being impaired at work.
Yeah.
But you have to be careful regarding the actions you take. You want to make sure that if it is a medical marijuana situation, that you're at least documenting it a little differently and making sure you're still protecting yourself from discrimination claims and the such.
Yeah, that makes sense. So we can tell workers they can't have marijuana at work. That's not the same thing again as, other things. All right. Can I tell workers they cannot use prescription medication at work if it's unsafe? I know some of you are waiting for this one. Well, maybe.
So we engage in the interactive process and we go through it all.
Right. You're not allowed to ask people about the prescriptions that they're using as a general rule. That's considered a medical examination or a prohibited medical inquiry under the Americans with Disabilities Act. So you can ask when the inquiry is job related and consistent with business necessity. So, that's going to vary. Obviously, if the job is driving and or is otherwise very safety sensitive, then you probably have some leeway to ask these questions. And to say, hey, we need to know if whatever medications you're taking may bear warnings. And so we write the policies. This is in your policies, this is in your drug, your sample policy from the organization. But in case you're wondering, why is that in there? It's because actual use of prescription medication may need to be accommodated within these laws. So, what can our New Jersey policies requires a little bit weird formatting, but it's okay to drug test as long as your policy follows both the New Jersey Supreme Court's guidance on whom and how to test, which is not a statute, it's a case, and the New Jersey law on marijuana. And I should have added, and Lauren, the Jacob, what is the last? It starts with a K.
Jacob Koenig
Jacob
Act.
Koenig Act on medical
Koenig, yeah.
marijuana, but that can be complicated because it's not like a yes, no. And I will tell you that if you are like any of the clients I work with, they're just like, it, just tell us if we can test or not. I'm like, I'm sorry. Yes, you probably can, but you do have to go through the process. And if any of you are in human resources and have to administer, for example, reasonable accommodations for individuals with disabilities, you'll know that we say we have a policy. We treat everyone alike under the policy. This is like a canon of employment law, except if it involves a medical condition or a disability, we have to do an individualized assessment. And it's called it and do an interactive process. And so it's the one place where your desire to have a policy that is fair and even-handed and is applied across the board runs into the possibility that there may be individual accommodations that need to be made. And so, it's not that you're wrong, and it's not that it's all that complicated. It's just that every time this comes up, we like you to provide, to apply the individual circumstances to what is going on. So,
Mary, you can tell people that they cannot have marijuana products at work.
No, you cannot carry marijuana at work. It is so we'll get into this in a bit when we talk about what Congress is doing, and you'll see why you might want to, take that position. I mean, half the time you may not be aware that they have it, especially if they're vaping, right? Because it's quite easily hidden, but it is still a federal crime. Simple marijuana possession is still a crime. And so a lot of employers would really prefer that people leave it at home. And that's okay. So I promised to do this, and I'm just going to put this up here. I'm not going to we're not going to talk about this, right? But in terms your your rules on drug-free workplace, what can our New Jersey policies require? We can require pre-employment drug testing for everything, including THC. And we'll talk about why that's okay in a minute. Doesn't mean you can turn everyone away. Some with medical marijuana uses get accommodated, right? But you can test. You can test for reasonable suspicion for everything, including THC and alcohol. You can probably do post-accident testing as long as you're focusing on the individual causing or contributing to the accident. Somebody asked about OSHA. OSHA really doesn't like it if an employer has a policy that says anybody who gets injured gets tested, because it looks like they're being hassled for reporting an injury. On the other hand, OSHA doesn't care if you test everybody who causes property damage. So the rule of thumb is, and this is good, from the way New Jersey case law is going as well, to focus on, did this individual cause or contribute to the accident? A lot of the time, right, the Venn diagram of people who get hurt at work and the people who may have been impaired at work, is overlapping by a great degree. But if somebody drops something on somebody else, I want you to test the person who dropped something, not the person who got hurt. Post-accident testing, possibly including THC if there's a reason to believe they might have been impaired. Random drug and alcohol testing of safety-sensitive workers only. That's New Jersey case law. Return to duty testing following a policy violation. Follow-up drug and or alcohol testing following a policy violation. And of course, you can always do any federally mandated drug and or alcohol testing. So without getting into that in any more specifics, you have model policies, but just these are all okay under New Jersey law. The testing. What you do with the results, as Lauren and I kind of went through just now, may have some more nuance, particularly with respect to marijuana. All right. So this is a fun topic. Wait, is marijuana legal? I don't know how many of you were paying attention when President Trump issued an executive order on rescheduling marijuana, but federal agencies have actually been working toward rescheduling marijuana for quite some time now. Under the Biden administration, the DEA administrator said, hey, we should make a change. What does that mean? Marijuana is currently Schedule 1 under the Controlled Substances Act, that with LSD, right, and some other things. That essentially is a schedule, if you will, or a classification that the federal government has applied to drugs that have a significant have no medical use or value and a high potential for abuse. Opioids, certain opioids and cocaine are Schedule 2. They can be used for some medical treatments, but high risk of abuse. And then you step down to Schedule 3, which includes some other types of opioids and other medications that can be abused. The recommendation that was made in the administrator of the DEA in 2023 was to reschedule marijuana to Schedule 3. I'm gonna pause here and say, like, this is actually super complicated. It's not the same thing as legalizing. It would make marijuana, the plant, right? And generally, as the ways I say it, a prescription medication. So anyone could get it by prescription, but that doesn't mean necessarily that anyone could get it without a prescription. And so, how do you prescribe marijuana, the plant? Prescription rules require a certain dosage, right? Quality control, things like that, that haven't happened yet. So it's fairly, challenging for them to just reschedule and then theoretically at least bring the entire marijuana industry under the control of Congress and the Food and Drug Administration, as well as the DEA. So they recommended that it be controlled under Schedule 3. And in 2024, the Department of Justice, again, under President Biden, issued a proposed rule to implement the rescheduling. And the way rulemaking in Washington works is so much fun. It's no. They publish a notice in the Federal Register with the proposed rule, and they give at least 90 days for people to comment. They received more than 43,000 public comments on the proposed rule. And as you can imagine, they run the gamut, right? So they have to review all of those comments and they have to think about responding. They have to think about modifying the rule, and they are supposed to have an administrative hearing. The last DEA administrative law judge, as I understand it, certainly the one who was in charge of this, retired in August. There's been a lot of retirements from the federal government. So everything is hung up. So in December of last year, President Trump issued an executive order on increasing medical marijuana and cannabidiol research. Yay! And all of my employers and some of the employees are like, yay, marijuana is legal. Like, that's not what executive orders do. The president essentially told DOJ to move with all reasonable speed to finalize the rescheduling. This is challenging. And what I'm going to tell you is nothing is happening. Okay? It is politically challenging, and it was politically beneficial for the president to issue this award because he has pro-marijuana business interests coming and talking to him. It's a business. It's pro-business. We're going to make money. There's also anti-marijuana cultural interests that are ascendant in the GOP. Healthcare interests fall on both sides of the issue. So where we are now, I mentioned this earlier, is that there's a federal statute that's up there on the screen that makes simple possession of marijuana a federal crime. Congress has never moved to change this. They haven't introduced it. What they have done is enact budget legislation saying federal funds can't be used to prosecute medical marijuana users if they comply with the state medical marijuana rules. And so federal prosecutions actually have increased in the last 6 months to a year for simple marijuana possession for when it's recreational or when people are dealing. The Department of Justice under Trump actually rescinded the Biden administration's hands-off policy here. So let me just tell you, in Washington, D.C. right now, we have people being prosecuted for possession of marijuana, although the District of Columbia, with its limited home rule authority, has legalized marijuana for possession. They've mostly gone after people who are selling it because DC made no provision for selling marijuana. So yeah, oh yes, Congress just passed legislation barring DC from legalizing marijuana. So, what's going to happen here if marijuana becomes a Schedule 3 controlled substance? In theory, at least, it will be. I mean, certainly it will be subject to regulation. You cannot get Schedule 3 controlled substances in the United States without a prescription. Don't know whether they would try to walk back the recreational marijuana laws. I assume business interests would make that nearly impossible, but whether it then became lawful to use and possess and to avoid, federal consequences, we would still have a two-tiered system at best with what we're looking at right now. Here's an interesting one for those of you who are in the transportation industry. If marijuana becomes a Schedule 3 controlled substance, the current congressional legislation that made transportation drug testing mandatory goes out the window. They only have the authority to test for illegal drugs, not for prescription medication used without a prescription. And so there's a lot of concern from those industry members as well as health and others who are concerned about, over the road safety, pilot safety, things like that, where if marijuana is rescheduled, they may need to pass new legislation talking about how that would be treated in the transportation industry. And right now, I think I've mentioned this earlier, just there is no Americans with Disabilities Act obligation to accommodate medical marijuana use, whether on or off the job, because it's not legal. And the ADA allows employers to take adverse action based on current illegal drug use. So if that changes, then individuals who use for medical reasons will probably have some of those. So somebody said, like, how is it that semi-synthetic opioids got added to the testing since they are legal by prescription? It's a great question. They were allowed to be added for, they're still excused if they have a script for them, right? But remember, you can't have a script for marijuana other than Marinol, which would be excused, right? Marinol and Epidiolex have some THC in them, really low amounts. But not the, like, you go to the dispensary with your card and you try different products and you use what you need until you feel better. That's kind of the entire inconsistency with the prescription system, is that you have a prescription and people are able to know what they're getting. And there's a lot of, penalties, right, for people who use for products, right? Like if you go, if you get a script and you get a product and you're either allergic to it or it causes side effects that hurt you, there are remedies for that. There are legal remedies. There are punishments, right, for drug makers who don't make those drugs pure and clean. And that's another thing that's a little bit different with marijuana. So it's just it's a whole shift in mode and model of how it is used. And so I have no idea how this will turn out, in case it's not clear. But it is messy, and that's why it's messy, because it would be essentially like saying, everyone, if you got it, use it. And by the way, the federal government is not responsible if you get, a lung infection from using this and whatever. So they have to figure out how they want that to come down. They certainly, I think, would like to avoid another situation like they had with certain opioids that were Scheduled 3 and then turned out to be highly subject to abuse. So again, what does the New Jersey Cannabis Regulatory Enforcement Assistance and Market Modernization Act say about marijuana use by workers? Well, that's changed too. And Lauren and I talked about this last year. So we kind of talk about more like what's the fallout from this. But you will recall, I hope you'll recall if you were here last year, but New Jersey said, hey, recreational marijuana is okay. We already had medical marijuana. Recreational marijuana is okay. And also, you can't take adverse action against workers who use marijuana away from work, as long as they're using in accordance with state law and going to be the right age, things like that. Or if they come to work impaired. Well, a lot of employers who had drug testing programs apparently kept testing, and particularly applicants. And what happened was this case made it to the federal district court in New Jersey, which had to interpret state law. And then it made it to the U.S. Court of Appeals for the Third Circuit. And briefly, CREMA does not contain any provision saying that, they've been discriminated against, if you will, for using marijuana away from work a right to sue. It, the law says you shouldn't be discriminated against, but there's no way to enforce that. Is the bottom line, right? So there's no cause of action under this regulation, and there's also the way the court looked at it is they said, well, what about public policy? What is the public policy of the state of New Jersey? Certainly, this statute expresses the public policy of the state of New Jersey that people should not be subject to adverse employment action because of their off-work use of marijuana. And this was an applicant case. Clearly, applicants are not using marijuana at work, not at your workplace anyway, right? And the court said, guess what? The public policy of New Jersey can be a cause of action. You can sue for wrongful discharge or for violation of public policy in New Jersey, but that only applies to employees. We've never recognized a public policy claim for an applicant. And therefore, you can test people for marijuana in New Jersey on an applicant basis and turn them away if they test positive and they don't fall within the state medical marijuana law. Lauren, did I get it right? What did I miss? Because I've got, well, does this mean we can go back to testing workers for marijuana, right?
Right. So exactly. So basically, it's still against the law, but the district court and Third Circuit held there's no private right of action. So basically, the risk for employers who do that, it's pretty small, right? Like what happens to you? What's your penalty? At the moment, it seems like there's not really much. Few things about it. It was the federal courts. We're kind of waiting for this to come up in the state court system. I'm curious as to what the state court would say about it. They tend to have significantly more liberal judges, and they might be like, it's our statute. This is how we're interpreting it. It might change. I'm surprised I haven't seen any action about them amending the law. That would be like the easiest fix. Like if anyone actually cared, like, hey, let's add in a provision here saying that they have a private right of action. That's what the court said we were missing. They didn't do that. So that's a little odd.
So to prepare for this presentation, I will note, I went online and just checked all of the online cases to make sure there was nothing new. And I didn't see anything that's even challenging out there right now. So this seems like maybe employers who care will test and employers who don't care will just say, you know what, I don't want to get involved. Are you seeing that?
Yes. And it's kind of lines up because even before this case, there are a lot of employers who just did not want to get rid of this pre-employment testing. It's interesting because to me, the pre-employment testing is the least concerning. Like you haven't hired someone yet.
Yeah.
They're doing what they're doing, but you still can't do anything really for current employees, obviously.
Well, yeah, let's get to that, right? So like I wanted to I'll just put this slide up, but it's employment. This decision is limited only to applicant testing. Fair?
Exactly. Yes. So New Jersey has a case. We call it a Pierce claim. It's Pierce versus Ortho. It's where our public policy employment law comes from, and says you have the right to bring a lawsuit for wrongful termination in violation of public policy. So we expect that any current employees terminated and they think it's in violation of CREMA and that their rights were taken, that they can, bring a claim under that, but that it doesn't apply to applicants. One thing I'll note is almost all the New Jersey employment statutes are fee shifting, which is why we see so much litigation, because the plaintiffs bar can take on a case, and as their reward for taking up the cause of an employee who's been wronged, they get their fees if they prevail at all. If you just sue, the wrongful termination claim under Pierce, under our case law, it's not fee shifting because it's just a normal tort. So we generally see less litigation under it anyway, because it's harder to find attorneys who want to take that on. So even though the cause of action does exist, it still is, not something that I think would necessarily be incredibly utilized. Maybe, but I'm not sure there's an appetite to go into like a very drawn out litigation, lots of discovery if it's not fee shifting.
It's interesting, right? So what I've got on the screen here is actually like kind of a pull quote from CREMA. And employers cannot refuse to hire any person and I just put lined through what I think the effect of that law is right now. Like employers cannot discharge or take any adverse action against an employee because they do or do not use cannabis products. It doesn't seem to be, they can refuse to hire people. But of course, this is a pull quote just from that statute, and you still need to contemplate the medical marijuana law protections that New Jersey law provides if you're looking.
Now,
Okay.
here's an interesting fun fact about New Jersey, because New Jersey doesn't seem to really follow the rules. It's not really our thing. We're kind of the Wild West sometimes. So I recently had a case before the New Jersey Division of Civil Rights, which enforces like the law against discrimination. And it was an individual with medical marijuana who claimed that they were discriminated against because of their disability. But when there was a probable cause finding, we had to conciliate, we had to meet with the DCR and go through everything. They were trying to take the position that they can enforce CREMA. And they were trying to get all our policies regarding recreational marijuana and like nothing having to do with accommodations. So we argued it's not part of their purview. This doesn't really fall under that. But I'm curious to see if the New Jersey Division on Civil Rights tries to get some involvement in this, because even if there's not a private right of action, they might be able to enforce some of these laws. But I haven't seen a claim just based under this, but it's kind of the government seems to understand this hole that's been created and they're trying to close the loop. But for some reason, the legislature hasn't caught up. So
right. So, I mean, I feel like, Lauren, you're going to volunteer to write an update for this group if that happens,
yeah,
right? Yeah, if it changes. I mean,
100%.
The big takeaway here is like, can workers sue employers despite CREMA? Yes, for discrimination under the LAD, under state law. Whether they will succeed, we don't know, right? We're just here to provide information about things to consider and be aware of. And so I did a TLDR slot for those of you who have zoned out on this. Review all your employment decisions involving the use of cannabis or marijuana carefully before deciding how to respond. That's our best legal advice right now. You can hear us debating it and we enjoy it, right? But like, we know you don't enjoy that. We're lawyers, we're geeks. We enjoy that. So I have a slight digression here on, can we require someone to go to treatment? And this is just to you kind of do a little consciousness raising, because I know in the past, and I'm sure still, we've got many participants in this webinar that provide these sorts of services and work with employers that want to have that. It's not all about drug testing. So this was the factual example that I promised you, and I'll just read it quickly, which is: Kerry came to work with really red eyes today. It's the second time in 3 weeks. He's usually on time, but lately has been looking disheveled. The work is getting done late, and his usually cheerful demeanor of a few months ago has evolved to being silent, uncommunicative, and unfriendly. Thus far, he hasn't made any real mistakes in his work. Madison, his manager, wants to give him a mandatory referral to the Employee Assistance Program. Do you agree this is a good idea? So you can either put it in the chat or you can think about that for a minute. But I'm going to ask you, what additional information would you like to have? You can certainly put that in the chat as well. So it's like, you're the employer right now. So yes, we have one vote. Yes, this is a good idea. Let's send Kerry to a mandatory referral to EAP. Anybody else brave enough to tell me, or anything that they would like to know? No, has there been a meeting? Okay, not mandatory. So has there been a meeting, like a disciplinary meeting, to ask him about himself? It could be a health issue, absolutely. EAP might figure out if it's a health issue. Might not be EAP just for substance abuse. So we have a lot of disagreement here. Some people want to investigate with coworkers and do a reasonable suspicion evaluation. That's a good idea, right? There are pros and cons. I have a lot of employers who don't really want to get to the investigation stage right away. They're like, well, we're not really sure, but why don't we just do a mandatory referral to EAP and let them sort it out? They can figure out if he's okay, whether he needs anything. He has been late a little bit. So here's why this is a good question for us to think about now. And the person who said, need HR to meet and check with them, yes, but we are HR for this purpose. So we have to decide what to do. Absolutely. This just does fall to HR. HR is going to go to the management though and say like, well, what have you talked to him? What else have you observed? So here's the thing. There is a case fairly new out of the US Court of Appeals for the 10th Circuit, which is Colorado. Don't worry about where it is. What you need to know is this is a case that was brought by the Equal Employment Opportunity Commission, which is the federal agency that enforces the discrimination laws, including the Americans with Disabilities Act. And the holding of that case is if you give someone a mandatory referral to EAP, that is an adverse action that is sufficient to give that person a federal lawsuit against you. Why? Because until June of 2024, most courts held you had to have an adverse employment action before someone sued you for violation of federal law. And an adverse employment action had to be something fairly substantive, denial of a promotion, termination, discipline.
It has to be a change in the terms and conditions of your employment. And, employers often made the argument, oh, just sending someone over to an EAP, it doesn't change the terms or conditions of their employment. They're just spending an hour somewhere else. It's
right. And then the federal law has changed. The federal law is like anybody that, is an adverse employment action could be a transfer. I've seen cases now that said like, somebody argued, they lost on this one, that their boss responding to them in, a different colored font in all caps in an email was an adverse employment action, not getting training, things like that. So a mandatory referral might risk a lawsuit. And so what I'd like to know, right, is, okay, he's been late a couple of times. You might make a recommendation as opposed to a mandatory referral. And by the way, you can still if you make a recommendation or say, hey, we noticed you've been struggling, if there's anything up, just so you know is available. But once you say, we need you to go and get checked out. And in the case, I haven't given much more detail in the case. This is a woman who just apparently did her work fine, but was telling her coworkers allegedly, I'm thinking about killing myself. And they've quite reasonably were like, maybe we should get some treatment. They said that could be some harm and it could be her litigation could go forward. So what I want you to do is just think this one through. And if the person has definitely violated your policy or you're very, very worried, a mandatory referral may still be the correct thing to do, but have it be a thoughtful decision. You guys have the poll up, right? Bert, do you want to talk about that?
And also just as a reminder, this is all just, we're trying to raise issues for you, and this is just educational. It's not, legal advice. So don't act on it and be like, Nancy and Lauren said I can do this. This is just kind of to get you thinking and be educational and teach you about some of what's out there.
Excellent. Well, of course, as always, Nancy and Lauren, thank you so much for giving us a comprehensive presentation on the recent developments and what employers need to be doing. And we do have time for one question before we get to the final comments, but I do want to direct everyone's attention first to the Drugs Don't Work in New Jersey survey. If you could please just take a few moments there and go ahead and put your replies in there for the questions on the poll that was just shared with you for those who are attending. So thank you so much. If you could just take a few moments on that. Just one question for the two of you, and then we'll get to your.
Actually, before we do that, Bert, can we just briefly tell them about the psilocybin legislation?
Yes.
Do we have time for that? Okay, I'm just gonna go forward to hang on. There we go. Because Lauren's been tracking this issue. As you fill out the survey, I just want you to just get that headline. Essentially, can you guys...
Basically, New Jersey recently passed a law that is creating a psilocybin therapy pilot program and allocating money to it to conduct research. It initially began as a much larger bill where they were looking to legalize it. They were looking to have employee protections similar to the way CREMA does for marijuana. It's been really trimmed down, cut down. It's a pilot program. They're doing research on how psilocybin, which is like magic mushrooms, works in
This is the
treatment
big one.
or therapy. The reason it's important is, marijuana, it all began as doing research and then legalizing medical marijuana, and it's kind of grown. So there's, a thought that this is likely, step one, and that there is more to come down the road.
Yeah.
Wonderful. We do have time for just one question for the two of you, just a very brief reply if we could, and then we'll get to your final remarks. The question that we have, how does an employer handle a situation when someone comes into work smelling like marijuana? And especially it gets a little murky when there are people in recovery in the workplace. If we could just get a brief answer from the two of you, and then we'll get to our final remarks.
I
Wow.
usually, I'll let you go, Nancy, if you want to
No, I
go.
was just gonna say, wow, about the recovery part. Yeah, go for it. Take it on.
I've been telling employers I think it's really important to have, grooming policies. I normally have a policy you have to come to work in like clean clothes, well cleaned, no strong odors. And so while you can't use that alone as necessarily a basis that someone is impaired, you certainly can say that's not an appropriate way to arrive at work and you have to come in clean clothes. Like maybe you were wearing that the night before while smoking or doing something, but regardless of whether there's any other reasonable suspicion to test someone, you are absolutely allowed to tell people they can't come to work in smelly clothes. I am
Nancy,
fine with
something quickly from you.
Yeah, just at the part where, if it's a recovery, people are in recovery. I don't know whether that was a referral to marijuana or not, but if you have people and rules about, your program, let's say you are a provider of substance abuse treatment, it might be a little bit different in terms of what you can expect people to do away from work, given their role perhaps as counselors. So I would say get some individualized look at that. But it's okay to tell people I agree with Lauren, they can't come to work smelling like marijuana because of a number of reasons, many of which are a lot less significant that you might have people in recovery there who would prefer not to be exposed to that kind of thing.
Wonderful. And we are approaching 12 noon, which will, of course, will mean the end of our program, Nancy and Lauren. So we do want to give you a moment just to offer your final thoughts on the subject. And Lauren, why don't you go ahead and go first for our final remarks?
um, oh, I don't know that I even have final remarks. Just, it's important to just remember most things are individualized, but employers can have policies still to keep their workplace safe. And you're not, your hands aren't completely tied. You're not prevented from doing, any testing at all or from taking steps necessary to, ensure you have a safe workplace.
Yeah,
Nancy, our final words come from you.
same thing. I hope this has helped give you the confidence that you know that there is a next issue, but that employers do have rights as well as employee rights, and that, if somebody comes in with a situation, feel free to suspend them with pay if necessarily, if necessary, but take the time to slow your roll and look into it, and you'll get to the right decision.
All right. Well, thank you very much again to Nancy and Lauren for this presentation and for sharing your expertise on this issue. We know these are challenging times for employers when it comes to handling marijuana, CBD products, and that the opioid crisis is still having an impact on employees and employers. I hope you leave this webinar with ideas on what steps you need to take to ensure you have a safe, healthy, and drug-free workplace. Please contact the partnership if you need assistance updating your policies and procedures. The partnership will continue to monitor new developments to keep our members fully up to date. We know one industry that has been hit particularly hard by the opioid crisis, the construction industry. The partnership is looking into collaborating with leaders later this year to promote a more proactive approach when it comes to opioids and pain management. If you are in the construction industry and would like to take part in this initiative, please contact Bill Villas, Drug Free Workplace Coordinator for the partnership. His contact info will be on the follow-up email that you'll be receiving. Reminder that a recording of the webinar and the slides presentation will be sent to all who have registered. And if you'd like to receive a certificate of participation, please respond to the email when you receive the slide presentation. Thanks to all of you who attended the program, and on behalf of the Partnership for a Drug-Free New Jersey, we certainly wish you the best as you move forward on this most challenging issue. Have a good day.
Thank you, Bert.
Thanks, Bert.